two things to note about me. I am actually down in Brown County on a staff retreat right now, and I'm working off of Mark's hotspot. So if I get a little patchy at any point, just feel free to carry on without me, and I'll join back in when I can. Um, I also got a little bit of a head cold going on, so if you can hear like the scratchiness in my voice, that's also what's happening there. But um, guys, thank you so much for being here. This is our last training session for the 2 week experience agent training that we've been on. So thanks for sticking with it and for showing up today. Much appreciated. I'm really excited about this session. Josh has joined us before and has been riveting and super helpful as we try to navigate the waters of real estate law. So excited to have him back again, and thanks for coming. Josh, to get started with you, can you tell us a little bit about who you are? I'm not even going to try to like say all the names of your law firm, but I would love if you could do that. That would be great.
Yeah, so my name is Josh Robertson. I work with a law firm here in Indianapolis called Cohen, Gerlich, and Glazier. And I've been practicing real estate litigation and transactional law in Indianapolis for, I think I'm in my 20th year now. And yeah, it's always, I get involved in residential real estate transactions quite a bit on the litigation side. And so it's always kind of fun to share some of the experiences that I have and what I see out in the world to try to help you guys, make your practices go easier and help your clients. And then also maybe give you some insight into what the end result looks like when things go wrong and people end up in court. How did they get there, and maybe what you can do to help your clients avoid that situation.
Yeah. Josh, before we kind of dive into some scenarios, can you tell us like how the hell did you even get into real estate law? Like that's kind of a niche. Like how did you find your way there?
Yeah, so growing up, I grew up in Woodruff Place here in Indianapolis, and my parents always owned a handful of rental properties. And so I kind of just grew up in that environment. And when I became an attorney and you have to kind of decide what you think you're going to do with yourself, I just had a natural interest in real estate. And my dad was a contractor also. So, I was kind of grew up with him rehabbing houses. And so it was just always kind of an interest of mine. And yeah, when you think about what you're going to do with your law degree, then I've kind of just found myself in that area naturally. And then also the firm that I'm with, we have a number of attorneys that do nothing but real estate transactional work, mostly commercial. And so those guys they try their hardest to not set foot in a courtroom. And so they need a litigator to handle the courtroom side of things. And so that was a good fit for me.
Yeah, that's great. So we talked a little bit via email about kind of things that you're seeing in this market, specifically with appraisal gaps. Do you mind just kind of launching into that scenario and talking people through like how to avoid ending up in court via that situation?
Yeah, so I think my partner is Leslie Gibson, who I'm sure a number of people here know. So I on a daily basis, I'm hearing what's going on out there on the streets in the real estate world, and she recently, with the market being so hot and buyers submitting offers grossly in excess of list price. People are often running into situations where you agree on a contract price, but then you've got this issue of the appraisal, meeting that price, or, if the buyer's relying on financing, how are you going to deal with that issue? And so people are coming up, you guys are on the front lines of essentially drafting contracts, and not everything fits squarely within the forms that you use. So you have to come up with this language on your own. How are we going to deal with this appraisal gap issue? And when Leslie first encountered that recently, it brought to mind a case that I had a number of years ago, where the agents had drafted a purchase agreement to try to address an appraisal gap, and the language essentially said, I have to try to paraphrase because this is a number of years ago, but here's the price that we agree upon. However, if the appraisal comes in below that, then we'll agree to adjust the price accordingly, something to that effect. Well, the seller's agent didn't think about the fact that there was no floor in that proposal. And so the appraisal comes in really low. And I don't recall offhand if this was a residential or a commercial transaction, but the appraisal came in way lower than anyone could have expected. And the buyer said, great, let's get to closing. Let's close. And the seller's like, whoa, 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 no way. Like this is, we can't do this deal. And so that was a great example of something that, everybody probably kind of knew what they were intending between themselves. But when the contract doesn't say that, and the contract isn't clear and doesn't cover all of these contingencies, then a real problem can result. I think that case, ultimately got settled, but talk about a really tough situation for the seller to be in, and the seller's agent especially. So, the important thing there is to, from the seller side, think about what it is that what the contract is saying, and you probably want to make sure that there's some sort of floor built into that the purchase agreement won't go below that. And I think that that's a great example of especially what people are dealing with now with the appraisal issue, but it can really go to any kind of contract provision that you're drafting that's outside of the form terms of the MIBOR documents, that if you're going to get into the territory of drafting language, you really need to spend some time making sure that it says exactly what everyone's thinking and that you're doing your best to cover those issues. And if it gets really tricky, you might want to tell your clients, if it's something kind of beyond that, that maybe they need to talk to an attorney.
Yeah. Josh, I'm curious, is there anything like in this current market that we've been experiencing for the last couple of months where there's these, people offering all cash, or like I'll cover the appraisal gap, or, just some kind of outlandish things that we've been seeing in the last couple of months? Is there anything that you're looking at that, like as a real estate lawyer, and saying like, ooh, this is going to get some people into some hairy situations?
I would say that appraisal gap issue is the one that that comes to mind the most. And the discussion that I've had with different real estate agents is, from the buyer's perspective, and I think this is a really important point in terms of trying to help your clients avoid litigation. So even if you win, litigation you're losing if you're involved in litigation. If you're just a person that's trying to sell your house, or you're a person that's just trying to buy your house, you want to move on with life. You don't want to be dealing with lawyers and courts for the next 2 years of your life. And so a buyer, in that perspective, the buyer's agent may say, well, I'm not going to put a floor on the purchase price in there because that's the seller's problem. Let them catch it. Maybe we'll get away with something, and then we can be like, aha, well, okay, great. Do you want to go prove that you're right in court, or do you want a contract that expresses what everyone agrees upon and what the true intent is, to make this transaction close and everybody move on with their lives? So, I don't think that it benefits anyone to draft a vague provision that may be sort of a gotcha type situation for the other side, because rarely does it go that easy for anyone. A seller in that situation isn't going to just lay down and sell their house for way, way less. They're going to do what they can to raise different defenses to that. So that really, I think that issue brings up the broadest thing to kind of talk about with the current market and things being so hot and people getting creative to make deals go down. I think the biggest thing is just to make sure that you have a clear agreement that's drafted very, very clearly and specifically.
Yeah, that's so good. Josh, let's hop over into the next topic you mentioned about sellers disclosures and how to walk through that well.
Yeah, so by far, disclosure issues are the main thing that attorneys are dealing with in residential real estate. I mean, hands down, that's what everyone's coming to us to deal with. And it's a tough thing to deal with, because from the seller's perspective, you don't want to highlight the scars or the issues you've had with your home. You're trying to present the best picture possible. And the buyers, I mean, it didn't used to be like this, but buyers now really are, especially when they're paying premiums for homes, they're expecting full disclosure. And the buyer's view on what full disclosure is very, very different than what sellers typically is. And what I typically see, I mean, clearly you have the situations where you have a fraudulent seller who is clearly hiding things, not disclosing things, doing everything they can to cover things up. But that's rare. Much more common, you have someone who's lived in a house for 30, 40 years, and they've kind of just lived in the house and they've fixed things as they've come up. And of course, something goes wrong, and it's especially if it's in an area of the house that normal homeowners don't access, like the roof or the crawl space, or the attic space. If it's an unfinished attic, they're not going up there, they're not crawling around on the roof inspecting the chimney and the flashing and et cetera. So they're relying on contractors. And as you guys all know extremely well, there's all different different kinds of contractors out there in the world. And so a homeowner will have a leak, let's say, or something wrong with the chimney, and they'll get multiple quotes from different contractors, and the quotes will be all over the board. One contractor comes and says that, hey, you've got to rebuild your entire chimney from the ground up, and we've got to do all this stuff, and it's going to cost $60,000. Someone else comes out and says, we just have to fix this flashing here, and that's it, and it's going to cost $1,500. And so the homeowner naturally says, well, hey, I've got a good feeling about this $1,500 guy. We're going with him. And they pay to have that work done, and they think that the problem is fixed. Well, lo and behold, 2 months after closing, there's some huge leak or something going on, and the buyer says, hey, here's this problem. And you'd be surprised how often buyers will end up calling companies to come give them estimates to repair a problem. And that company will say, hey, yeah, we were just out at this house a year ago, and we gave them the $60,000 quote and told them it was this huge issue. I mean, that happens all the time. Or the neighbors will come over and be like, oh yeah, the Robertsons, had a big problem with this chimney, and and there were trucks out here, and so then the buyer says, hey, you got this other quote that you didn't tell us about. You knew that this problem was bigger than what you said it was. And the seller says, no, we were, yeah, these people said that, but we thought that was ridiculous. This guy said it was just this, and as far as we knew, that took care of the problem. And it's not a really, really clear situation about who's right and who's wrong in that, but all the time there suddenly are lawyers involved, and a case like that can cost tens of thousands of dollars in attorney's fees, because both people are trying to prove they're right and they're trying to get their fees paid under the attorney fee portion of the contract. And that kind of stuff keeps guys like me in business, those kind of disputes. And so I think the moral, there's not a lot you agents can do about that necessarily, but what I think that you can do to try to help your clients as a listing broker is to just be very, very diligent about talking to your clients about what their duties are, and to say that they need to really, at the end of the day, think hard about what kind of work they've had done, what paperwork they have, what estimates they've gotten, and what they think they need to disclose to try to avoid problems. I just had, and it baffles me how often I see selling brokers filling out disclosure forms for their clients. I mean, it happens. And I just had some clients recently on the selling side who had an active pending case, like litigation pending concerning the house. It was concerning an easement. And their broker, when they go to sell the house, fills out the disclosure form and checks no, that there's no pending cases. And so luckily my clients read it and were like, oh, hey, no, we've got this, we've got a case going on. We've got to disclose this. And they caught it before the buyer signed, but after they had already signed it once. And I'm just thinking, what in the world is the broker doing filling this out for his clients? And this is on a $1 million plus home, which those are the people that really sue over over issues when you're in that kind of a market. So I think that counseling your sellers about not being flippant about filling out that form and about really thinking about what information they have that they potentially may need to disclose. And at the end of the day, it's going to be their choice how they fill that out. But you should not be doing it for them. And, you should really, don't try to paint too rosy of a picture about the house, because I think it's better to maybe err on the side of disclosure. And maybe it's a little bit harder of a road getting things sold than potentially having a lawsuit over things, because it really is kind of a gray area, and homeowners are sort of at the whim of contractors, and you get one contractor that comes out there and says something crazy about this issue that could be kind of far out, and you think it's bigger than what the problem really is. But a buyer is going to, if they ever get their hands on that document, they're going to wave it around and stomp their feet. And, most of those cases ultimately get settled, but at great expense and delay. So I think that's really, if there's anything in terms of trying to help your clients stay out of messes, that's a big one, is the disclosure issues.
Yeah, that's so good, Josh. Guys, I have a couple more questions that I could ask Josh, but we have intentionally left a large portion of this time open for you. This is your free 40 minutes with a real estate lawyer. I mean, just go ham, ask anything you need to. So does anyone have any questions they would like to ask of Josh? You can feel free to unmute yourself or to drop them in the chat. Okay, while you're formulating your questions, the one thing I had wanted to ask you, Josh, is last time we had you here, you talked about making sure when you had contractors, or if like a realtor was gathering contractors to quote things out, that make sure the quote is in your client's name and not in your name as a real estate agent. Can you talk more about that?
Sure. That's another one. That's a good one. And I think that it's really something that's good for brokers, not so much helping your clients, but helping yourselves. There's so much pressure put on you guys to be helpful to your clients, to keep things moving along. I mean, the deadlines just keep getting shorter and shorter in your industry. And so a lot of brokers, because they want to keep things moving and they're kind of just jamming along and trying to help their clients, they'll contact the inspection companies, they'll contact the contractors to come out and fix things. And they're the ones that are deciding oftentimes which contractors are going to come out and do the work. And the client has no idea. They're just saying, I don't know, my broker just sent someone over here and fixed it. And at the end of the day, you could have a problem where something doesn't get fixed correctly and it turns into an issue, and the work estimate, the work invoice are both in the broker's name. The contractor comes up and they said, man, the only person I ever talked to was the broker. I never even met the owners of the home. And the owners of the home say, yeah, we never even talked to this guy. We don't even know what work he did. We don't know anything. We just were told to send a check. And then suddenly now as the broker, you're involved potentially in the middle of a dispute you have no business whatsoever being in the middle of. And it's a huge distraction to yourself, and it can get, costly and very problematic. There's no reason for you to ever be in that position. It's just simply, it's going too far. And, you guys have such tough jobs to navigate, repair issues, financing issues, legal issues. The best thing I think that you can really do is sort of be a quarterback and help, farm that out, put your clients in the right direction, to rely on people, to do those things, but don't insert yourself too much, directly in the middle of it. I mean, it's fine if you communicate with contractors to coordinate work, but you need to be very clear. This invoice needs to be in the client's name. The client needs to pay them, not pay the broker somehow, and then the broker turns around and pays. I mean, do what you can to make that relationship be between the people that it needs to be between, and not yourself. Some I think I've even seen like inspection companies put inspection reports in brokers' names, and the customer, the homeowners, like, or the buyers, like, man, we don't even know who the inspection company was. We have no idea what that process was at all, and it's just doesn't need to be that way at all, and should not be. And I see, seeing it firsthand with all of you guys and friends of mine, and Leslie, just the amount of pressure that, and the questions you get from your clients to know everything and to do everything. I know you want to be as helpful as possible, but you also have to kind of step back at some point and just say, hey, I can point you in the right direction, but it's not what my responsibility is, or not my area of expertise, and you need to rely on these other people and communicate with them.
Yeah, that's such good advice in both the seller's disclosure and, the kind of contract work that we're talking about now, just to put some stuff back on your clients and tell them, like, no, you need to fill out your seller's disclosure, or you need to order the inspection.
Yeah, I've seen some brokers that have sort of their own like contracting company on the side, and so they're representing the seller, then the seller has to make repairs, and then this broker is having his company do the repairs or subbing out the repairs, and so all this paperwork is in the broker's name, and the sellers are like, man, we don't even know what happened. It was we've had nothing to do with any of these repairs being done. It was all our broker. And so if something wasn't done right, go talk to him. And just shake my head. I don't understand the dynamics of an arrangement like that.
Yeah, that gets messy real quickly.
Yeah. If someone doesn't have a question right away, one other thing that I thought about that could be helpful is when, and I see this come up often, where from the seller's perspective, when a buyer says that they are not closing and a dispute arises about the earnest money. So the seller is wanting to retain earnest money, the buyer wants their earnest money back. So neither party is willing to execute a mutual release. And I've seen a lot of brokers feel kind of frozen at that point about whether they're allowed to move on and start working with other buyers, accept another offer, that type of thing, because they will sometimes get advice that, well, you can't accept another offer until you have a mutual release from the prior. And I don't agree with that. I think that when a buyer has clearly indicated that they are not going to close the transaction, that they're done, they're not going to move forward, you are then, as the seller, you have a legal duty to mitigate your damages. And what that means is you can't just sit back on your butt for the next year and say, oh, well, we had a year's worth of carrying costs and all these other expenses and damages. And then the question is, well, what were you doing to try to resell the home during that time? Well, nothing, because these buyers breached and they're responsible for everything. Well, that's not the case. I mean, you have a duty to try to sell the home and keep your damages as low as possible, and then that's what you can go after the buyer for. So to sort of not be actively engaged in trying to relist and find other offers, you could be setting the seller up for some problems, or the seller can be setting themselves up for some problems. So my advice is, from the seller side, when you have a buyer that conveys that they're backing out of the deal, then you can make it very clear, communicate with their agent in writing that, hey, you've expressed, or your client's expressed, they're not going to move forward with this deal. We are considering that a termination of the contract, that you are electing to terminate the contract. And therefore, we are going to start soliciting backup offers to try to, in an effort to mitigate our damages and sell the home. Then that puts the ball in their court to either say, oh, no, we're still trying to work this deal, or if they don't respond at all, which is more often the case, then I think you're clear to move forward and not feel hamstrung because because it can take an unknown period of time to try to get earnest money issues resolved. I mean, I've seen people litigate cases just over earnest money before, which is yeah, makes very little sense at the end of the day.
Right.
Some people love to be right.
You're going to end up losing all that earnest money on court fees regardless. So
yeah. No judge wants to have a case end up in front of them where there's $7,000 in attorney's fees on both sides over $2,000 in earnest money. I mean, judges don't care who's right and who's wrong in that case. They just are mad that people are there to begin with. So
yeah,
it's never good.
Jacob Adu, looks like you had a question. Hit us with it.
Yeah, I'm actually in a very relevant situation right now, and I'm actually curious what Josh thinks about. Josh, I have my last correspondence, and you literally nailed the situation right on the head. My last correspondence with the buying agent that we're in a little bit of a dispute with at the moment was, my client is no longer interested in this property. And we're going to start looking for, he didn't say we're going to start looking for another deal. My bad. He said, my client is no longer interested. Would you sign this mutual release? Is that, in your eyes, enough of a foundation for me to move towards a backup offer?
Yeah, I mean, I guess I would have to be careful that this would not be legal advice in that specific.
Of course,
context,
sure.
but yeah, that would be the type of thing that I would consider a buyer backing out. That's pretty clear language that the buyer is expressing an intent to breach the contract and not close. And so the best thing to do is to just follow up. If I understood correctly, you're on the seller side, to follow up with a written communication, just sort of driving that point home. Hey, we understand that the buyer, has elected to not continue with this transaction. We consider that a breach. We think that they have a duty to close. And so if they're not moving forward, number one, we believe that we're entitled to retain the earnest money. And number two, we're going to try immediately to start mitigating our damages and seek backup offers. Not
sure.
backup, but new offers.
Sure. And then I guess my question then becomes, at what point does that buying agent get to imply that and not to say that anyone has any foul intentions, but at what point does the buying agent get to imply that because the mutual release has not been signed, that they are not mutually releasing the contract that they're currently in right now? Because if we're communicating that we feel entitled to earnest money, then isn't there something along the lines of them saying, well, heck, why don't we just move forward with the transaction if we're really going to be out the earnest money? And the discrepancy was something that might imply that. So they haven't said that, but is that something that you could foresee them doing in terms of protecting their interests?
Yeah, and that's why I think that follow-up communication is really important, because the buyer can't have it both ways. They can't say, hey, we want out and we want our earnest money released to us. Oh, but wait, we're just kidding. If you're not giving that to us, we want to move forward. I mean, they need to express their intention, and the seller can't just sit around being hamstrung for too long. So the parties need to come to a conclusion on what their positions are quickly. And I think that's how the seller's follow-up communication to sort of box the buyer in to commit to a position. I mean, not box them in, but to get them to commit to a position by restating what you understand their intentions to be, and then putting the ball in their court to state whether they whether they agree with that or not.
Thank you very much, Josh. I appreciate that.
Anyone else have any questions or legal quandaries they would like to present before Josh this morning?
I have one. Can you hear me okay?
Yep,
Yes.
perfectly.
Okay, great. I have a client that has a land contract from 10 years ago with a property company. And he, at the time, and it's diluted, so bear with me, please. And I won't hold you to it, but just kind of made me wondering where I should go from here. At the time that he signed the land contract, he was not a legal citizen. I'm not sure if the contract is legal at all. And he is now still paying on the house, and the property management company will not give him a total amount of what is owed and where he stands after very clear communication and lots of questions to that point. And so he's kind of wondering, now that he is a legal citizen and has been paying on this house for 10 years, what actions he can take.
Yeah, well, that's tough. I mean, if the contract doesn't have, I would think that the contract should have enough information in it to calculate that. What was the original principal amount of the seller financing? What's the interest rate? And then you kind of go from there. If no one has really kept good accounting records over the years of what payments were made and what payments were not made, that's going to be, I would say, shame on both of them in that position if no one's keeping track of what's been paid. But what they would have to do is each side is going to have to do their best to recreate the payment history and present their position on what they believe is owed under the contract presently. And ultimately, if they can't reach an agreement, it would be up to a judge to decide that issue based on who has the most credible evidence of the history of the transaction and calculation of where things stand. I would hope that the land contract at least has, an interest rate, a principal amount of the original seller financing, and some information about what was expected to be paid. Is it a monthly payment, annual, what have you? And then from there, the parties are going to have to dig through their records to try to be able to prove up what's been paid or received over the course of that contract.
Awesome. Thank you.
Sure.
That's helpful.
I'll jump in really quick. I'm happy to take another question as soon as someone comes up, but I'll kind of just keep moving through a few things. Another one that I see over and over and over again, and I know that it comes up with you guys a lot, is parties not following corporate formalities. And you've got out of state House Flipper LLC that is the seller, and it's, you know, some random LLC name, but then they're signing all the documents in the name of John Smith with barely any reference to the LLC, or back and forth. Sometimes it's John Smith, sometimes it's the LLC name. That kind of stuff creates all kinds of problems. You got to just stay on your clients. If they're using an LLC, then everything needs to be signed John Smith, member such and such LLC, and make sure that everything that's followed kind of throughout all of the paperwork throughout the entire transaction. That's a big frustration that attorneys deal with a lot, is people utilizing corporations, but not really understanding kind of the administrative side of that and how important that can be, and making sure that you follow all the corporate formalities throughout different transactions. People having LLCs but then not maintaining them, so they get dismissed by the Secretary of State, or dissolved, I mean, 7 years ago, and so before the transaction comes about. That happens all the time. So kind of work with your clients on making sure that stuff is all taken care of and done properly. Another really common thing, I remember I told Leslie this when she first started, when she first became a licensed broker. I said, read the purchase agreement once a week. Once a week, you should read your purchase agreements from top to bottom and try to understand what all of those provisions mean. I know that, Pete, you just kind of get caught up in the midst of your work and things are moving so quickly. But it always surprises me that, we're dealing with these MIBOR forms, and people that have been practicing real estate for a long time won't know that there's a certain provision in those documents, or what they mean. They know that, oh yeah, it's there, but I've never really understood what that means. You should, on a regular basis, just read through the documents, and I think you'd probably be surprised sometimes what's in there. And if there's probably a lot of stuff in there you think, man, I know I've always read that. I've read that 100 times. I have no idea what it means. Maybe spend some time to try to find out what the importance of some of these different provisions can be. One that comes to mind is there's a principle in real estate law that if there is something that's a part of the agreement that is not taken care of before closing, but then the parties proceed to closing, that unless you demand prior to closing that issue gets addressed, and it could be a repair issue, it can be a title issue, it can be all kinds of things. But if you close, then that issue becomes sort of merged in the title, and you can't subsequently enforce it against the seller unless the explicit terms of the contract were that the duty would survive the closing. And there's actually a clause in the MIBOR purchase agreement that says that all of the terms and conditions that make up this agreement, that are in the purchase agreement or in addendums and that type of thing, shall survive closing. That's a very good provision in there that a lot of people aren't aware that it even exists, or if they've read it, they don't necessarily know what it means. That's one that comes to mind that I've seen kind of come up with people before.
I have another question I can shoot you.
Sure.
So I was recently in a transaction on the investment side where we had signed a PA and gotten as far as maybe 2 days before closing to find out that the seller had previously signed a PA, which had been recorded at the county recorder's office and was now a notice of interest, and that we were unable to close the transaction. And so our attorneys informed us that we can go ahead and file a similar notice of interest, but we had actually wound up filing that NOI, I think what turned out to be 2 hours after closing, after they had closed. And so title reached out and said that the lien is present, but that it is now a lien on the new property holders. It'll cloud their title. If they ever go to sell the property, then that lien will be made available. And I guess my question then becomes, this new owner didn't do anything wrong, and this lien that is now on their property, we really just wanted to get our due diligence and get some damages taken care of from the seller who had led us through this entire lengthy process. So I guess that it's a two-part question. One is what would be a good recourse for that, and two is, given the situation that I was the seller or the new buyer, and I found a lien on a property post-closing that had nothing to do with me. How do you navigate a situation like that where you're dealing with someone else's issue?
So was the lien recorded before closing?
Our lien was recorded literally an hour after they closed, so it did not get the chance to go through.
When you say our lien, I'm a little unclear about.
The notice of interest that we placed back on the property, because we had equally signed, he had signed 2 PAs, and if their notice of interest was going to crash our deal, we wanted our notice of interest to prevent them from closing so we could figure it out, which it just didn't happen in time.
Well, so you're saying the buyer recorded their own sort of Liz Pendon's notice against the property.
Mm-hmm.
Well, they could simply just release that. They could record a release of the Liz Pendon's notice or the notice of interest that they recorded.
Sure. So then what would happen if that so let's say that notice of interest was on me. Let's put me in the second or the first, I would say, buyer's position. How would I navigate a lien that was placed on a property because of something that the previous owner did, but it wasn't recorded in time to affect that previous owner?
So you're saying if there's some third party out there that recorded
Yeah, because right now my lien is sitting on this poor guy's property, and we're probably just going to have it removed because we have nothing to do, and we're not going to seek legal action against this. But I guess just like as a thought, just as to go through the process, like this guy now has a clouded title. If you ever go sell that property, we're going to be notified. Right now, if it wasn't me, and we're obviously going to let that pass because they didn't do anything wrong. We're not going to come after them for anything. But at the end of the day, that is still a lien on that person's property, right? So what's he to do in the event that I wasn't just willing to release it?
Okay, so with any kind of lien that's filed on a property that's not released, it depends on what kind of lien it is. First, so mechanics liens only have a 1-year lifespan. And if the holder of the lien does not file a lawsuit to foreclose that lien within a year of when it's recorded, then it becomes void. I think Liz Pendon's notices are a little different. Broker liens are probably the same type of, I don't know offhand, but I think that they would fall under the same statutory rules as a mechanics lien and would also expire within a year if not sued on. If someone's filing a Liz Pendon's notice saying, hey, I've got an interest in this property, I'm supposed to be allowed to buy this property, but then the seller sold it out from under me to someone else. The long story short is the party that wants to get that removed would have to file a lawsuit against the person that asserted the lien, and the court would have to decide, yeah, that interest is void and is not legitimate, and the court could order it released.
Okay.
Otherwise, and you can also do what's called a quiet title action, where you file a lawsuit in the court and you name all the parties that have asserted claims against the property, and serve them, and then also publish notice in the paper. And if people don't step forward to assert those interests, then the court will, quote unquote, quiet title to the property against those interests, and then the buyer then has, or the property owner then has a clean title.
I just found it very interesting that there was not much scrutiny in me filing that lien. I mean, I just would in and just say, hey, we don't want this to happen. And if anyone had less than pure intentions, that could really just throw major hurdles in people's transaction process.
It's a great point, and something I tell people all the time. Anyone can go record anything. I could scribble a nonsensical note on this piece of paper and go record it against any one of your houses at the recorder's office, and everyone would look at it and say, well, what in the world is this? I don't even know what this is. But yeah, anyone can record anything. And an unscrupulous contractor, they often record liens against people's property as a way to sort of force leverage to get paid, even if they're not entitled to it. And it's very frustrating, but it happens all the time. It's a risk of the industry for sure. Yeah, there's no sort of threshold or gatekeeping on recording liens. Anybody can record their claim, and then if it can't get resolved by agreement, then only the courts can resolve that.
And
Thanks,
Josh, Lisa just popped in via the chat and said, in this situation, what role would the title company / title insurance play?
Well, so the title company, first of all, their first order of business will be to find a way to deny coverage and say it's not something they're responsible for. But if it was a lien that existed before closing and it was of record and not disclosed by the title company in the commitment, then they'll pay the claim. I've got one claim going right now where there was an easement that was not caught by the title company. My clients bought the property and then suddenly find out that their property is subject to this easement, and so that claim is getting paid by the insurance company. But if it was either not timely, if it wasn't recorded timely to where it wouldn't have shown up, and so then they can deny coverage, or if they did disclose it but then you close anyway with knowledge that lien exists on the property, then it's not going to be a covered issue.
Is there time for me to ask a question? I got on here late, so you might have already addressed this, but
Go
Sure.
for it, Jenny Bliss.
Okay.
Take it away.
this is Jenny. Yeah. I have clients that I'm on sell side. Buyer's agent called after the inspection, said my clients want out. They're never going to buy this house. And I told him, you owe me a response. So he sent me a response with $100,000 price reduction. And my clients accepted it because they were ready just to move on. And now he, of course, was freaked out about that. And so now that he went digging, kind of trying to find ways that my clients may be misrepresented on the seller's disclosure. But my question, I guess, is we accepted the response, but we still just don't have any recourse for the earnest money.
So you represent the seller.
Yeah.
And the seller sort of called the buyer's bluff and
Pretty much.
accepted this significantly reduced offer.
And they were serious about it. Like I told the buyer's agent, I said, I would never tell my clients to play with $100,000. Like I didn't say, hey, we'll get the earnest money if you sign this. I never said that. I mean, once they started considering it, I said, well, if you do, the worst thing that will happen is you'll get their earnest money. But now they're not even, now they want to release with them retaining earnest money. And I just feel like, why do we even have rules?
Yeah, no, I don't, I mean, if you've got a closed purchase agreement now where the buyer's offer has been accepted and was timely accepted, I don't know how they're gonna get their earnest money if they just want to walk away. I mean, well, I mean, Jenny, the reality of the situation is, unless everyone agrees, then no one can force the release of the earnest money until a court does.
Yeah.
So that's extremely unfortunate. But no, I don't see how the buyers have any legitimate claim to retain earnest money.
Yet if they don't sign the release, we don't get to keep the earnest money. And then like I think you might have mentioned earlier, litigation is ridiculous.
Yeah.
So
So we did kind of talk about this. So my advice to someone in your position is, if the buyer can't have it both ways. They can't say, well, we're going to close, but if you're not going to give it, but we'll also walk away if you give us our earnest money. But we don't want to close. They can't kind of be very vague like that. And so if they have expressed their intention of not moving forward and not closing on the transaction, then the seller has their own interests and their own duty to try to mitigate their damages by going with another offer to sell the property as soon as possible, so that they don't have a year's worth of carrying costs, et cetera. So I always advise sellers, send a very clear written communication to the buyer's broker that, look, you on such and such date, you stated that your clients are not going to proceed and that they want their earnest money back. We consider that as a breach of the purchase agreement. And we consider that an expression that you're not going to close on this transaction. And therefore we're going to move forward with other offers in an effort to mitigate our damages.
yeah,
And that sort of puts the ball in their court to then say, oh, well, no, we're just kidding, we'll close. And then they've got to close.
Yeah.
And
they've sent a mutual release with them retaining earnest money.
Yeah.
My problem is, the reason that we accepted that response is because their inspector did discover an issue that we have to fix. And so like, we have to make this repair before we go back on the market, and the contract voids on the 20th. So we don't really have much, like, I'm kind of wondering, like, we could probably just start on this repair. I told them we should wait till the 21st to start, but technically we could start on this repair, I guess, and just move forward.
Right. Yeah, I think that, I guess maybe I don't understand all the nuance of that situation, but I think that, yeah, don't, unless if the buyer is on the hook for the transaction and your seller is willing to do all of their obligations to close the transaction, then the buyer doesn't have a way out, and
Right.
with also getting their earnest money.
But the only way to force that is court.
The only way to force, yes, getting the earnest money in your client's pocket at the end of the day would be court. That's right.
All right. Well,
It
yeah.
can't be settled.
And
I think that they could move on with other, they don't have to be hamstrung by this wishy-washy buyer. They can say, hey, the earnest money will just sit there in escrow for who knows how long, but we're moving on with other buyers.
And I technically can move on with this repair before our contract is void, right? Like, we could start the repair now.
Oh yeah.
Okay.
Especially if that's, yeah, I mean, it's their home, and yeah, absolutely.
Okay. Because I mean, they've definitely made it clear, and their thing is now that they're saying that the seller misrepresented something on the SD, which of course they didn't. And he actually asked me for a new SD, and I was like, what? No. Like, that's exactly what you are not getting. I'm like, the seller's disclosure was when we listed the house, they are disclosing what they knew about the house. So if we don't make the repair and we try to list it again, well, then we'll have to make the seller's disclosure changed. But so anyway.
Yeah.
Yeah, you can be right all day long and still not get what you're supposed to get. So
Yeah, that's for sure. Especially when, with earnest money issues are really frustrating because it's usually not enough money to justify a whole lot of hullabaloo.
Yeah.
But, it is what it is. And of course, the title company is not going to release it until they've got their interests covered.
Yeah.
So I always tell people, like sellers, look, move on with your life, move on with trying to get the property sold. You can deal with the earnest money issue later. And
Yeah.
maybe after you get the property sold to someone, maybe the sellers will be like, look, we're moving to Panama. We don't care about that $5,000. We'll just sign a release and be done with it.
yeah, moving to Panama doesn't solve your problems, but the other
Jenny, you know
thing-
that from experience.
yeah. What about that certified letter that you're supposed to send and give them 60 days?
So, in what regard? What does
You know,
that?
that there's that letter that you send the day your contract's void, and it's a certified letter. And then if no one responds in the 60 days, then the earnest money is automatically released.
I'm not aware of a statute or anything about that. It could be, is it something that's in the escrow agreement?
Yeah, like when you can look it up, like in the, I don't know, Stephanie, maybe you can chime in. But we've done this in the past. We've had transactions where it's like, if you hit this wall, the contract goes void because you've missed the date, and you send this certified letter. And if nobody responds within 60 days, it's automatically released.
Yeah, I'm not sure what the basis for that is. It could be something that's in some escrow agreements that has that kind of a provision.
Yeah.
My real world experience, I've never seen a title company voluntarily release earnest money until they've got either a court order or an agreement signed by both of the parties.
Yeah, I don't know if this is a MIBOR regulation or what, but I know that we've definitely had it on at least one transaction on our team.
Yeah,
Um,
it's common practice for brokerages, at least in this area, but I don't know what the legal standing of it is.
Yeah, I would be interested in looking at that if someone, Rosie or Jenny, if one of
Yeah.
you guys, Jenny, if you could maybe, if you find that, maybe send it to Leslie or something and she can forward it to me to take a look at, or Rosie, if you know where that is.
Yeah, I guess, I mean, I know, but I even found it on the internet last night as I was trying to dig through like the legalese and try to figure out how I would word it. But yeah, Mark would probably have to answer as to what authority that, statute comes from, where it,
Mhm.
it stems. But
Yeah,
yeah,
Marcus had to do it on one of his properties, so
Yeah.
I'll ask him this
yeah,
morning.
and we actually had one where it was a certified letter to a wrong address, and it still counted because it was the last known address, and they lost their earnest money because they didn't respond within 60 days. So it can't sit in purgatory indefinitely.
Yeah, I'm really interested to know. I've never heard of that. So I'm intrigued
Okay.
to know what the source of that is.
All right. Well, I'll get more info on that.
Yeah, that'd be
Thanks.
great. Thanks.
That's great. Well, I want to be conscientious of everyone's time. I know we're a little bit after 10. Guys, thank you for your thoughtful and intriguing questions. I appreciate you guys participating, and Josh, you especially. Thank you so much for joining us today and for sharing your wisdom with us. Much appreciated.
Yeah, no problem. I enjoy it, and it's good for me also to hear what kind of things you guys are facing in your practices. So
Yeah.
maybe I even learned something today. If we can figure out what this 60-day provision is, that'd be. I want to find out. I want to know what that is.
Yeah, that's so great. We'll definitely send you more information, and we'll definitely be sure to have you back sometime soon to chat with us. So thank you so much for your time, and everyone have a great Thursday.
Yeah,
Cheers.
take care. Bye.